Governor. In the Indian Constitution, the state government system similar to that of the Union has also been adopted in which dual executive is found. That is, the governor is the constitutional head of the state, while the chief minister is the real head of the state executive along with the council of ministers. Article 153 to 167 in the sixth part of the Indian Constitution deal about the state executive. In the state executive, there are governor, chief minister, tri-councils, and advocates of the state, advocate general. According to the Article 153, there will be governor for each state. The provision has been added by the 7th Constitution Amendment Act 1956 that only one person can be appointed as governor of two or more states. All executive functions of the state are firmly done in the name of governor. The governor appoints the chief minister and other ministers after consulting with the chief minister. The governor advises the president in the appointment of the high-level officers of the state, such as advocate general, chairman public service commission, and the appointment of the chairman and the members of the judges of the high court. When the governor deems it necessary, the president recommends the implementation of the rule in the state, and at the time of president rule, he administers the administration of the state as an agent of the central government. The governor is the chancellor of the state universities and recruit the vice chancellors. Governor's executive powers. According to Article 154, the executive powers of the state shall be vested in the governor and he will use it according to the constitution itself or by its subordinate officers. Appointment of governor. According to Article 155, the president will appoint the governor of the state by the warrant including his signature and currency. Thus, he/she is nominated by the central government, but in reality, the appointment of the governor is done by the president on the recommendation of the prime minister. There are two traditions in relation to the appointment of the governor. First, the president shall not appoint such a person as the governor of the state of which he is resident. The president consults the chief minister of the concerned state before the appointment of the governor. Actually, the governor is the nominated person representative of the central government, but does not work under the central government. The post of governor is an independent constitutional post. According to Article 156 of the governor's posthumous and abdication of the governor shall hold office for 5 years from the date he assumed his office or till the president will offer the governor. However, will continue to hold the post till his term expires. Till then, the successor does not accept his position. The governor will be able to relinquish his post by writing with his signature addressed to the president. Note: the basis for the removal of the governor from the post has not been mentioned in the constitution. Qualification for appointment a governor. According to Article 157, a person will be eligible to become a governor only if he is a citizen of India. Second, has completed the age of 35 years. Terms for the post of governor. According to Article 158, the governor shall not be the member of the House of Parliament or a House of Legislature of any state specified in the first schedule. And if any member of the House of the Parliament or House of Legislature of any such state is appointed as a governor, it will be automatically understood that he has vacated his position in that house as the governor from the date he assumed his office. The governor shall not hold the post of any other benefit. Third, the governor shall be entitled to the use of the official residence without rent. Fourth, provided by the 7th Constitution Amendment Act 1956, where only one person is appointed as the governor of two or more states, the receipts and allowances received to the governor will be allocated in such proportion between those states by president's order. Fifth, the achievements of the governor, salaries, etc., allowances will not be reduced during his term. Note: in the Union Budget 2019-20, the salary of the state governor has been raised to 3.5 lakh per month. Oath or affirmation by the governor. According to Article 159, the third schedule of the Constitution, the administration of the post of the governor or the discharge of the acts of the governor, and by his full qualification, preservation, and immunity of the Constitution and all laws shall take oath to serve in welfare of people of the state and remain. The governor administers oath to the Chief Justice of the respective state high court or in the case of absence of the senior most judge. Governor's power and function. Just as the power of executive in the center lies in the president, the power of the executive in the state lies in the governor. The power and the functions of the governor are as follows. First, executive powers, governance. All executive related functions is done in the name of governor. Second, the governor's name is firmly written in all the functions of the state government. Regarding the work of the state government, he makes rules. According to Article 164, the governor appoints the chief minister and on the advice of the chief minister appoints the other member of the council of ministers. Each minister of the state administers the governor's post. Governor cannot remove the member of state public service, the state advocate general, and the state public service commission members. Only the president can remove them. According to Article 217, the governor does not have the right to appoint the judges of the high court of the state. But in the regard, the president consults the governor. The governor appoints the judges of the subordinate courts on the advice of the high court. Article 233. The governor appoints the state election commissioner and the and determines his terms and condition of services. The state election commissioner can be removed in special cases or circumstances in the same way as the high court judge is removed. He can get information from the chief minister about the administrative matters or any legislative schemes. He can recommend the president for the constitutional emergency in the state during the president rule in the state. His executive power expands as the representative of the president. He is the chancellor of the state universities. He recruits the vice chancellor of the state universities. The executive powers of the governor is extended to 61 subjects of the state list. If the governor feels that in the state it is not possible to run governance in accordance to the constitution, the situation of a peace breach has been created in the state, then by information the president in this regard, the president announces the emergency in the state. If in the opinion of the governor, the representation of the Anglo-Indian community is required in the state assembly, and if this community is not adequately represented, then he can nominate an Anglo-Indian member under Article 233 in that assembly. As per the provisions of Article 171(5), the governor nominates 1/6 member of the Legislative Council of the bicameral legislative, having special knowledge of practical experience in the field of literature, science, art, cooperative movement, and social service. Second, legislative powers. The governor is an integral part of the state legislature. Article 168. The governor has the following powers regarding the legislature. First, the governor can nominate the 1/6 member of the legislative council who have knowledge or practical experience of literature, science, art, cooperative movement, and social service. Article 171. Second, a member of Anglo-Indian community can be nominated in the state assembly. Article 333. He can convene or dissolve the session of the state assembly. Article 174. He can send message to any house or house of the legislations on the bills pending or any other matter. Article 175. Fifth, he addresses first session of every year after every election of the legislature. Article 176. After discussion with the election commission on the issue of disqualification of a assembly member, governor decides the matter. Article 192 clause 2. When the post of the assembly speaker and the deputy speaker is vacant, he can appoint a member of the legislative assembly for action. He presents the report related to the accounts of State Finance Commission, State Public Service Commission, and the Comptroller and Auditor General etc. in front of State Assembly. The governor has the power to reserve a bill passed by the state legislature to be reconsidered by the president. Article 200. In the following circumstances, the governor can keep the bill safe for the president. It risks the status of the High Court. Second, righteous, i.e., against the provisions of the Constitution, contrary to the policy elements of the state policy, against the welfare of the country. Power of issuing an ordinance. According to Article 213, the power of the governor to promulgate an ordinance in the special session of the legislature. When the state legislature is not in a session, i.e., when the state legislature session is not going on, the governor can issue an ordinance on the advice of the Council of Ministers. The ordinance issued by the governor is required to be approved by the state legislature within 6 weeks, otherwise it is terminated. Third, the maximum period of ordinance issued by the governor is 6 months. Note, the maximum period of ordinance issued by the governor is 6 months and 6 weeks. The governor can terminate the ordinance at any time. The governor can issue an ordinance on the subjects which the state legislature can make laws on. The ordinance issued by the governor has the same force and effects which is of the law issued by the state legislature. Powers of the president and the governor of issuing ordinance. A comparative study means when they can pass the ordinance. For the president, if neither of the two houses of the parliament is in the session. Governor, if the state legislature or either of the two houses where the state legislature is bicameral is not in session. For the president, ordinance has the same force which is similar to the act of parliament and its limit as per the act of parliament. For the governor, ordinance has the same force which is similar to the act of state legislature and its limit are in accordance with the act of state legislature. President, it will be placed on their table of both the house of the parliament when they are in recession. Governor, when the legislature is in recession, it will be placed in front of legislative assembly or on the panel of both the house of the legislative assembly where it is bicameral. President, any ordinance can be done at the end of 6 weeks from the reassembly of the parliament, or if the two houses pass the resolution of its resolution before the end of that period, then the passage of the second resolution will not be in force. Governor, any ordinance on the expiry of 6 weeks from the state legislature's recession, or if the legislature passes the resolution of its reprobation, the expiry of that period, and if it is the legislative council, then he agrees to it. So as the case may be, the legislative assembly will not be in force upon the passing of the resolution. Fourth, financial powers. A governor ensures that the annual financial statement, state budget, are presented to the state legislature. Article 202. B. Money bills can only be submitted in the Legislative Assembly after its prior consent. C. He can take advance from the state fund for the carrying of an unexpected expenditure. D. No demand for grant of any kind can be sought without his consent. E. Governor ensures that each recommendation for the Panchayati Raj made by the State Finance Commission will be put before the state legislature along with an explanatory memorandum of action taken on it. Article 243I. Each recommendation for the municipalities made by the Governor State Finance Commission will be put before the state legislature, including an explanatory memorandum of action taken on it. Article 243Y. Judicial powers. A. The governor has the power of state concerning the subject on which the executive power of the state is in extension the punishment of any person convicted of any crime against any law for forgiveness, its dispersion, break or avoidance of, or the power of suspension, avoidance or commute of the sentence. Article 161. The President consults the governor in the matter of the appointment of judges of the High Court of the state. Article 217. C. The governor can appoint, transfer and promote district judge in consultation with the state High Court. Article 233. D. He also appoints the person associated with the judicial commission of the concerned state in addition to district judges. In these appointments, he advises the state High Court and the state Public Service Commission. Article 234. Discretionary powers. Indian Constitution has given a discretion to the governor. The constitutional discretion received by the governor is as follows. A. Under Article 356, the governor has the power to recommend the implementation of the present rule in the state. B. Under Article 200, the governor can reserve a bill passed by the state legislature to send it for the consideration of the president. C. Under Article 167, the governor has the right to say that the matter on which the concerned minister has taken a decision but has not been submitted for a consideration of the cabinet, the governor may order the chief minister for its consideration. D. In the paragraph 9, clause 2 of the 6th schedule of the constitution, the governor of Assam has the right to decide on discretion matter of a dispute over the sharing of income from lease of mines between the Assam government and autonomous tribal district council. Under Article 371A 1b, the governor has been given the discretion to deal with internal unrest caused by rebel Nagas in Nagaland. Under Article 371C, the governor of Manipur has the obligation to ensure the proper functioning of the committee of the state legislature of the state legislative assembly, which is formed from the hilly areas elected by the people of hill areas. G. Under Article 371F are mentioned the Sikkim governor's privileges. H. Under Article 371 Clause 2, the privileges of the governor of Maharashtra and Gujarat states are given. I. Under Article 239 Clause 2, the governor gets discretionary power when acts as an additional charge in the neighboring union territories while acting as an administrator. In addition to constitutional discretion, the governor also receives his discretionary powers, that is, the governor, like the president, exercises discretion under the following circumstances. First, appointing the chief minister of the state belongs to the governor's own discretionary power. In the case of clear majority in the assembly, the leader of the majority party is appointed to the post of chief minister. In such a situation, the meaning of the governor's discretion is negligible. But if any party does not get a clear majority in the assembly of the state, or there is more than one leader of the leader's post in the majority party, the governor uses his discretion in this regard. Second, while dissolving the Council of Ministers, the governor can dissolve the Council of Ministers in certain circumstances from the point of view of the protection of the Constitution. If the governor becomes convinced that the state council is engaged in any such agreement, a conspiracy or anti-national act, the governor can dissolve the Council of Ministers under discretion if there is a danger to the unity and the security of the country. The governor is convinced that the majority of the Council of Ministers has ended due to change of party or for any other reason, then the governor can ask the chief minister to resign or to convene the assembly session to prove the majority. In such a situation, if the chief minister is not ready to convene the assembly session, the governor can dissolve the Council of Ministers. If the speaker does not resign even after the non-confidence motion is passed in the assembly for the Council of Ministers, then the governor can dissolve it. If an independent tribunal has convicted of the minister for corruption, then the governor can remove him from the post. Governor's immunities and privileges. He is not liable to any court for the use of the powers of his force and to comply with the duties. No criminal proceedings can be initiated in any court during the tenure as the governor. No court can order for his arrest or imprisonment during the term of the governor of the state. It is mandatory to inform this person 2 months prior to, before or after asking the position of governor, before or after the civil action taken by him personally. Status of governor. Parliamentary system has also been adopted for the states in the Indian Constitution, in which the governor is the constitutional head of the state, and in the governor all executive powers of the state has been constituted by the Constitution, whereas practically these powers are used by the chief ministers and the Council of Ministers. Thus, the governor is an Nominal executive head. The following provision of the Indian Constitution show the position of the governor. Article 154. According to Article 154 of the Constitution, the executive power of the state will be vested in the governor and he will use these powers through himself or his subordinate officers. Article 163. Article 163 of the Indian Constitution provides for the Council of Ministers to give help and advice to the governor. It has been said that except for the task of at its discretion, the governor will have a council of ministers to assist and advise the use of his acts, whose head is chief minister. Article 164. The following two provisions have been made in Article 164 of the Constitution. The governor will appoint the council of ministers, including the chief ministers, and they will hold the post of governors. The Council of Ministers will collectively be responsible to the State Legislative Assembly. It is clear that the determination of the actual role of the governor depends on the state and its independent and unbiased approach. In the last few decades, the position of governor has become very controversial. With his active political role, several suggestions have been given regarding the appointment and the role of governor, which are as follows. Recommendation of the Administrative Reforms Commission 1969. First, the governor should appoint such a person to be a governor who has long experience in public life and administration and who has faith in the ability to rise above party prejudices. The governor should not be eligible for the reappointment. Third, prior to the appointment of the governor, the tradition of consultation with the chief minister is a healthy tradition, which should be maintained. Fourth, in the manner in which the power of self-discretion should be exercised by the governors, discretion should be issued in the name of the president on the acceptance of the center and should be kept before the two houses of the president. Recommendation of Raja Manar Committee 1970. The appointment of the governor must be made after discussions with the concerned state government. The president should direct the governors to make the same decisions in the same political circumstances in order to develop healthy tradition related to special circumstances. Recommendation of Sarkaria Commission 1983. The appointment of governors should be with the informal consent of a chief minister of the respective state. The governor should not be appointed or on any other post except the vice president and the president when he is relieved. Governor are social and administrative credentials. The president involved in active politics should not be appointed as governor. The person involved in active politics should not be appointed as governor. Article 356 related to president's rule in the state should be used only if there is no other way. President and governor's veto power. Comparative study. President, general bill. All ordinary bill, when they came from both house of parliament, whether different or jointly passed, they are sent to the president for acceptance. In this case, the president has three options. The president can approve the bill, then the bill become the act. The president can stop his acceptance on the bill, such as the situation the bill is eliminated and the act cannot be framed. The president may send the bill for reconsideration to the house. If the bill is passed by the two houses without any change, then the president has the right to the veto of the postponement. Governor. General bill. All general bills are presented before the governor after passed by the legislature in the first or in the second opportunity. The governor has four options. The governor may approve the bill, then the bill becomes an act. The governor can stop his acceptance of the bill, then the bill is rejected and the act is not framed. The governor may send the bill for the reconsideration to the house if the bill is passed without any change by both the house and then bill is sent for the acceptance of the governor. Now the governor has to give his acceptance. In this way, governor has the right of adjournment veto only. Governor may keep the bill safe for the president acceptance. When the governor secures a bill for the president's approval, then there is no role of the governor in making of the act. If the bill is sent to the house or the houses for reconsideration or if it is repassed and sent to the president for acceptance, in the president has to give approval. That is, the bill does not require the approval of the governor. In the president, when a bill is reserved for the president recommendation by the governor, the president has three options. The president may approve the bill, after which it will become an act. He can stop his acceptance of the bill, then the bill will end and the act will not be framed. Third, the president can send the bill to the state legislature or the council for reconsideration. It is necessary for the house to reconsider it within 6 months. If the bill sent back to the president for the acceptance of some changes or non-reform, then the president is not obliged to accept it. That is, he or she can either accept or reject. Money bill. When any money bill passed by the parliament is sent to the president for the acceptance, then the president has two options. The president can approve the bill, then it becomes an act. When the president does not accept the bill, then the bill is over and the act cannot be created. The president cannot return the money bill for the reconsideration to the parliament. Generally, the president approves the form of re-establishment of the finance bill in the parliament because it is presented with the prior permission. B. When the finance bill is sent by the governor to the president consideration, then the president can stop his acceptance on the bill, then the bill gets over and the act cannot be created. Note, the president cannot send the finance bill for reconsideration to the state assembly as in the case of parliament. Money bill. Any finance bill passed by the state legislature and sent to the governor for the acceptance, the governor has three options. The governor can give his approval to the bill, then the bill becomes a law. The governor can stop his acceptance of the bill, which eliminates the bill, and the bill does not convert into an act. The governor may keep the bill safe for the consideration of the president. A. The governor cannot return the finance bill to the state assembly for the approval to the finance bill, as it is introduced by the legislative assembly after his prior permission. The governor reserves the finance bill for the consideration of the president. Then there is no role of the governor in regards of this bill. If the president approves the bill, then it becomes an act. This means that the governor's approval is not necessary in this matter. Issuance of an ordinance. The president can issue an ordinance only when both the house of the parliament or one house is not in session. The president can promulgate an ordinance only when he sees that such a situation has become necessary to take immediate steps. In case of ordinance creation power, the president has the powers as the coexistence of parliament, i.e., the validity of the ordinance issued by the president is similar to that of the act of the parliament, i.e., if the ordinance issued does not go through the parliament passage, it will become invalid. The president can withdraw the ordinance at any time. The president's power to promulgate an ordinance is not voluntary. That is, he can only make a law or withdraw an ordinance only in consultation with the Prime Minister's Council of Ministers. Ordinance issued in the president should be placed on the chairmanship of both the houses of the parliament. The ordinance issued by the president ends in the 6 weeks after the commencement of the parliament session. It ends in the situation even if both the houses of the parliament pass the resolution to reject it. No instructions are required to make the president's ordinance. Issuance of an ordinance. The governor issues an ordinance only when the both of the legislators in an bicameral assembly are not in a session or assembly in case of a unicameral house. The validity of the ordinance issued by the governor is equal to the act of the state legislative assembly, i.e., the ordinance issued by him, if it is not within the limits of the passage of the legislator, it will become invalid. The governor may withdraw the ordinance at any time. The power of the governor's ordinance is not voluntary. That is, he can only make a law or withdraw an ordinance only on the advice of the chief minister's led council of ministers. Ordinance issued by the governor should be placed in the assembly hall of the legislature. Ordinance issued by the governor ends in 6 weeks after the commencement of the state legislative session. This may also end earlier if the state assembly reject it and the legislative council where it is agree to this rejection. The governor cannot issue an ordinance in the following 3 circumstances without the prior instruction from the president. The president's prior approval is necessary for its presentation in the state legislature. If he considers the bill with the same provision necessary for consideration of the president. If the state legislature act is such that it become illegal without the approval of the president. Powers to pardon. Under the state law, the governor can suspend the penalties or mercy of the person convicted of an offense. Powers to pardon. The president can forgive, suspend, punish, or remit or commute sentence of any person convicted of any offense against union law. Even if he is found innocent, he will have to urge the president rather than the governor, but the governor can postpone it or ask for the reconsideration. The president can forgive the death penalty, reduce or can suspend or change. The governor can not forgive the death sentence. Even if anyone is punished for death under the state law, authority in India who has the right to forgive the death penalty, the president can forgive, reduce or change the punishment of the person convicted under the court-martial, military code. The governor does not have any such powers. Important points. Article 153 to Article 167 in the 6th part of the Indian Constitution deal with the state executive. The governor is the chancellor of the state universities and recruit the vice chancellors. The governor will be able to relinquish his post by writing with his signature addressed to the president. According to Article 155, the president will appoint the governor of the state by the warrant including his signature and currency. The governor administers oath to the Chief Justice of the respective state high court, or in the case of the absence of senior most judge, the governor cannot remove the members of the state public services. Important question. The legal head of the state administration in Rajasthan is the governor of the state. Which of the following power is not vested in the governor of the Rajasthan? To adjourn the assembly. The ordinance power of the governor is mentioned in Article dash of the Constitution of India 213. Which of the following is related to the special address of the governor? Article 176. Consider the following statement. Article 157 prescribes two qualifications for the office of governor. The governor should be member of the state legislature. Before appointment, the governor should have completed 40 years of age. So only first is true. The responsibility of the Council of State Minister is to the State Legislative Assembly. Which one of the following posts is not held by the governor of Rajasthan? Chairman, Aravali Management Board. Which of the following statements are correct with respect to the governor of the state? The executive power of the state are vested in it. तो ये सही है. Their age should be 35 years. ये भी सही है. They remain in their office only at the discretion of the president. ये भी सही है. The reason of his dismissal is mentioned in the constitution. तो ये constitution mention नहीं है. तो fourth option सही नहीं है. बस बाकी तीन सही हैं. तो second option सही बनता है. Chief Minister and Council of Ministers. Important points. Chief Minister. Chief Minister is the real and political head of the state's executive. He is the leader of the assembly. Parliamentary system of the government has been arranged for the union and the states in the Indian Constitution. Under Article 163 of the Indian Constitution, provision of the cabinet has been made under the leadership of Chief Minister to give help and advice to the governor. Chief Minister's post and his appointment. Article 164 mentions that the appointment of the Chief Minister will be done by the governor of the state and appointment of other ministers on the advice of Chief Ministers. The minister will hold the position till the governor will. The governor of the parliamentary system only appoints the leader of the majority party in the state assembly as the chief minister. But if a party does not get a clear majority, the governor uses his discretionary power in the appointment of the chief minister. In such a situation, the governor appoints the leader of the group of the largest party and asks him to get vote of confidence vote of in the house within a month time. The governor can appoint a person as a chief minister who is not a member of state legislature, but it is necessary for him to become a member of the assembly within a period of 6 months from the date of appointment. According to the Indian Constitution, the chief minister must be a member of one of the two houses of the legislature. Generally, the chief minister is elected from the lower house assembly, but sometimes a member of the upper house legislative council can be appointed as chief minister. Before assuming office, the chief minister takes oath of the office in front of the governor. Chief Minister's tenure. The Chief Minister's tenure as Chief of the Council of Ministers is usually 5 years, but his tenure depends on the support of the majority in the Assembly. The Chief Minister can remain on his post till the majority of the Assembly is in his favor. If the Assembly passes a no confidence motion against the Chief Minister, then the Chief Minister has to resign. The resignation of the Chief Minister is considered as a resignation of the whole Council of Ministers. Qualification for Chief Minister's post. No qualification has been prescribed for the post of Chief Minister, but for the Chief Minister it is necessary that he must be a member of the State Legislative Assembly, or within 6 months from the date of assuming office, he will be a member of the State Legislative Assembly. According to the judgment of the Supreme Court on September 21, 2001, any convicted person will be considered ineligible for the post of a Chief Minister. Chief Minister's function and the powers. The Chief Minister is the real head of the state government. The Chief Minister has a role in the state which has the Prime Minister at the center. Study the functions and the power of the Chief Ministers under the following headings. A. Constitution of the Council of Ministers. With the advice of the Chief Minister, the Governor constitutes the State Council. B. After the appointment, the Chief Minister prepares a list of those people whom he wants to include in the Council of Ministers. The Chief Minister's actual work is constructing the Council of Ministers is the Chief Ministers. It is also the function of the Chief Ministers to fix the number of the Council of Ministers. Now provision has been made by the 97th Constitution Amendment Act 2003 that the number of ministers will not exceed 15% of the total number of the assembly members, a maximum 30 in Rajasthan. The Chief Minister has the power to recommend the appointment of a person as a minister who is not a member of the legislature, but such a people is required to become a member of any legislative house within 6 months. Dismissal of ministers. According to the Indian Constitution, the state government ministers remain on their post till the governor's will, but they can actually remain in the office till the Chief Minister's wishes. So, distribution of department. The Chief Ministers also distribute the departments of the ministers of the government. There can be 3 categories of ministers: cabinet minister, minister of state, deputy minister. Some minister of state may be given an independent charge. Typical senior and influential leaders are made cabinet ministers, and compared to them, junior and less effective leaders are made state of minister of states and deputy ministers. D. Chairman of Council of Ministers. The Chief Minister presides over the Council of Ministers. The Chief Minister decides when and where the meeting of the Council of Ministers will be held and what will be considered. Although all the decisions within the Council of Ministers are often taken with majority, but such a decision cannot be made with which the Chief Minister does not agree. E. Coordination among various departments of the government. The coordination is made by the Chief Minister. The Chief Minister monitors the functions of the various departments and takes care of the policy of any department not affected by the other department. For this reason, the Chief Minister is called the Chief Executive of the state. F. Link between the Governor and the Council of Ministers. According to Article 167 of the Constitution, it is the duty of the Chief Ministers of each state to inform the Governor about all the decisions of the Council of Ministers related to the administration of the state and all the decisions of the Council of the Ministers related to the administration. He will give the information related to the administrative and legislative establishment of the affairs of the state to the Governor. Chief Advisor to the Governor. Chief Minister is the Chief Advisor to the Governor. He advises the Governor on the every problem or issue of administration. Constitutionally, depending on the advice of a Chief Ministers or not depends on the Governor. H. Leader in the Legislative Assembly. The Chief Minister is leader of the State Assembly because he is the leader of the majority party in the Assembly. Disintegration of the Legislative Assembly. The Chief Minister is responsible to the Legislative Assembly, and when he does not get a majority in the House, then he has two options. First, to give the resignation. Second, he can dissolve the House by consulting with the Governor. Governors have not accepted the recommendation of the majority last Chief Minister to dissolve the Assembly rather than try to form a new government. If the majority won Chief Minister demands to dissolve the Assembly, then the Governor has to admit it. Appointments. All major political and administrative appointments in the state are done by the Chief Minister. The appointment by the Governor are only according to the advice of the Chief Minister. For example, the state's Advocate General, the chairman of the State Public Service Commission and its member, the chief of the different boards. Chief Minister's position. The Chief Minister has the same position in the state, which is of the Prime Minister of the Union. The entire governance of the state run is in the name of the Governor. But in reality, the power of the Governor are used by Chief Minister, as he is a leader of majority party in the Assembly. Until the Chief Minister has majority in the Assembly, he is a real ruler. B. Chief Minister's Office. Just as the Prime Minister's Office is a PMO is established in the Union government keeping in view Prime Minister's position and his engagement, similarly Chief Minister's Office CMO is established to provide him secretarial and administrative assistance to the Chief Minister. The Chief Minister's Office is also a part of the overall secretarial system, which administers the administrative support to the Chief Minister. Just as the Cabinet Secretary does the work related to the Cabinet, the Chief Minister's Office edits the work related to the Chief Minister. Organization of CMO. The Chief Minister's Office in Rajasthan was established in the year 1951. The head of the office is a senior officer of the Indian Administrative Services. It is called Chief Secretary. The Chief Minister's Office functions mainly on administrative tasks and assistance in fulfilling the assurance given by the Chief Minister, implementation of policy decision and related functions related to departments under the Chief Minister. Chief Minister of Rajasthan at a glance. Hira Lal Shastri, 1949 to 1951, first nominated Chief Minister of the state. C.S. Venkatachari, 1951 to 1951. Appointment by the central government. Jaya Narayan Vyas, 1951 to 1952, appointed. Tikaram Paliwal, 1952 to 1952, first elected Chief Minister. Jaya Narayan Vyas, 1952 to 1954. Mohanlal Sukhadia, 1954 to 1957. Then again Mohanlal Sukhadia, then again Mohanlal Sukhadia, then again Mohanlal Sukhadia, till 1971. Then Barkatullah Khan, 1971 to 73, died during his tenure from. Haridev Joshi, 1973 to 77. Bairon Singh Shekhawat, 1977 to 1980, first non-Congress Chief Minister. Jagannath Pahadia, 1980 to 1981, the first Chief Minister of the Scheduled Castes. Shiv Charan Mathur, 1981 to 85. Hiralal Devpura, 1985 to 1985, Chief Minister for 16 days. Haridev Joshi, 1985 to 1988, second time Chief Minister. Shiv Charan Mathur, 1988 to 1989, second time Chief Minister. Haridev Joshi, 1989 to 1990, Chief Minister of the third time. Bairon Singh Shekhawat, then again Bairon Singh Shekhawat. It's between 1990 to 1998. During this tenure, he is the second time Chief Minister and Chief Minister for the third time. Ashok Gehlot, 1998 to 2003. Ms. Vasundhara Raje, 2003 to 2008, First Lady Chief Minister. Then Ashok Gehlot, 2008 to 2013, second time Chief Minister. Then Vasundhara Raje, 2013 to 2018, third time Chief Minister. Then Ashok Gehlot, from 2018 till now, third time Chief Minister of Rajasthan. Council of Ministers. Article 163. Council of Ministers to aid and advise the Governor. There shall be Council of Ministers with the Chief Minister as the head to aid and advise the Governor in the exercise of the functions, except in so far as he required to exercise his function in his discretion. The advice tendered by ministers to the Governor shall not be required in any court. In other provisions as to ministers, the Chief Minister shall be appointed by the Governor, and the other ministers shall be appointed by the Governor on the advice of Chief Minister. The total number of ministers, including the Chief Ministers, in the Council of Ministers in a state shall not exceed 15% of the total strength of the Legislative Assembly of the state, but the number of ministers, including the Chief Ministers in the state, shall not be less than 12. The provision was added by the 91st Amendment Act 2003. A member of either house of state legislature belonging to any political party who is disqualified on the ground of defection shall also be disqualified to the appointment as a minister. The provision was also added by the 91st Amendment Act of 2003. The minister shall hold office during the pleasure of governor. The Council of Ministers shall be collectively responsible to the State Legislative Assembly. 6. The Governor shall administer the oath of office and secrecy to a minister. A minister who is not a member of the State Legislature for any period of 6 consecutive months shall cease to be minister. The salaries and allowances of the ministers shall be determined by the State Legislature. Article 166. Conduct of business of the government of a state. Conduct of business of the government of state. All executive action of the government of state shall be expressed to be taken in the name of a governor. Orders and other instruments made and executed in the name of a governor shall be authenticated in such a manner as may be specified in rules to be made by the governor. The governor shall make rule for the more convenient transaction of the business of the government of the state, and for the allocation among ministers of the said business in so far as it is not business with respect to which the governor is required to act in his discretion. Article 167. Duties of Chief Minister. Shall be the duty of Chief Minister of each state to communicate to the governor of the state all decisions of the Council of Ministers relating to the administration of the affairs of the state and proposals for legislation, to furnish such information relating to the administration of the affairs of the state and proposal for legislations as the governor may call for. If the governor so requires, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by the minister but which has not been considered by the council. Appointment of ministers. The chief minister is appointed by the governor. The other ministers are appointed by the governor on the advice of chief minister. A person who is not a member of either house of state legislature can also be appointed as minister, but within 6 months he must become a member of either house of the state legislature, otherwise he ceases to be a minister. A minister who is a member of one house of state legislature has a right to speak and to take part in the proceedings of the other house, but he can vote only in the house of which he is a member. Oath. The governor administers to him the oath of office and secrecy. Collectively responsibility of ministers. Article 164 clearly states that the Council of Ministers is collectively responsible to Legislative Assembly of the state. All the ministers own joint responsibility to the Legislative Assembly for all their act of omission and commission. They work as a team and swim or sink together. When the Legislative Assembly passes a no confidence motion against the Council of Ministers, all the ministers have to resign, including those ministers who are from Legislative Council. The principle of collective responsibility also means that the cabinet decision bind all cabinet ministers and other ministers, even if they differed in the cabinet meeting. Individual responsibility of ministers. Article 164 states that the ministers hold office during the pleasure of the governor. This means that the governor can remove a minister at a time when the council of ministers enjoy the confidence of the Legislative Assembly, but the governor can remove a minister only on the advice of chief minister. Composition of Council of Ministers. The composition does not specify the size of the state Council of Ministers. They are determined by chief ministers. The Council of Ministers consists of 3 categories of ministers: cabinet ministers, minister of state, and deputy ministers. At the top of all these ministers stands the chief minister. The cabinet minister heads the important department of the state government. They are member of the cabinet, attend its meeting, and play an important role in deciding policies. The ministers of the states can either be given independent charge of department or can be attached to cabinet ministers. They are not member of the cabinet and do not attend the cabinet meeting unless specially invited when something related to their department are considered by the cabinet. Deputy ministers are not given independent charge of department. They are attached to the cabinet ministers and assist them in their administrative, political and parliamentary duties. They are not members of the cabinet and do not attend cabinet meetings. Rajasthan first nominated chief minister, Mr. Hira Lal Shastri. Rajasthan first elected chief minister, Mr. Tikaram Paliwal. The chief minister of Rajasthan who has both nominated and elected, Mr. Jainarayan Vyas. Chief Minister for the longest period in the Rajasthan. Chief Minister for the longest period in the Rajasthan, Mohanlal Sukhadia, about 17 years, 4 times. Mohanlal Sukhadia is also known as the maker of modern Rajasthan. Total nominated Chief Minister in Rajasthan, 3. Harilal Shastri, C.S. Venkatachari, Jainarayan Vyas. First and only minority Chief Minister in Rajasthan, Mr. Barkatullah Khan, death in 1973 during the tenure. Chief Minister for the shortest period of time, Shri Hira Lal Devpura, 16 days. The Chief Minister of Rajasthan who was an IS officer, Mr. C.S. Venkatachari. Rajasthan's first non-Congress Chief Minister, Shri Bairon Singh Shekhawat, Janata Party, 1977. First woman Chief Minister of Rajasthan, Miss Vasundhara Raje. Chief Minister who took oath of office 3 times in Rajasthan, Mohanlal Sukhadia, Bairon Singh Shekhawat, Mr. Haridev Joshi, Ashok Gehlot. Important question. According to the Article 167, the Constitution furnishing of information to the governor is chief minister's is duty. How many members having Rajasthan's Human Rights Commission according with the provision of the Protection of Human Rights Act 2006? 1 chairperson and 2 members. Who among the following chief minister of Rajasthan has never been a governor of any state in his entire political life? Bairon Singh Shekhawat. Consider the following statement and choose the correct answer by seeing the codes given below the statement. First, Minister of Rajasthan have hold office during the pleasure of Governor of Rajasthan. The total number of ministers excluding the Chief Minister, the Council of Ministers and the Governor shall not exceed 15% of the total number of the members of the Legislative Assembly of Rajasthan. After the 91st Amendment of Constitution of India, the number of ministers including the Chief Minister in Rajasthan shall not be less than 12. So first and third statement is correct. In the history of Rajasthan Assembly till 30 June 2016, how many times the motion of no confidence have been discussed? 4 times. Select from the following with the help of code given the Chief Minister's constitution duties. The Governor's decision regarding the administrations of the affairs of the Chief Ministers approved the Governor. The Chief Ministers approve the Governor regarding legislative proposals. The Chief Minister participates in the meeting of the National Development Council. The Chief Minister is a subject on which a minister has made a decision, but the Council of Ministers has not considered it to be held before the council when it is required by the governor. So all the options are correct. Who conducts or performs his responsibility in the absence of the governor? Chief Justice of High Court. Consider the following 2 statements. The governor of state remains on his position only till the president's will. Second, the governor is appointed by the prime minister. So statement A is right and R is wrong. Which of the following is not well matched? Article 154, executive power of the governor. Article 155, appointment of the governor. Article 156, eligibility for the appointment of governor. Article 163, minister of the state. So third option is incorrect. Article 156, eligibility for the appointment of the governor, because Article 156 belongs to term of office of governor. Ms. Vasundhara Raje became Chief Minister of Rajasthan for the first time 2003 to 2008. Who was the first nominated Chief Minister of Rajasthan? Shri Hira Lal Shastri. Who was the Chief Minister who remained Chief Minister of Rajasthan for the longest time? Mohanlal Sukhadia. Who is called the maker of modern Rajasthan? Mohanlal Sukhadia. How many Chief Ministers nominated as a Chief Minister in Rajasthan? 3. The Chief Minister of Rajasthan who was an ICS officer, C.S. Venkatachari. Who was the first woman Chief Minister of Rajasthan? Vasundhara Raje. In which year was the Chief Minister's office established in Rajasthan? 1951. Who was the first non-Congress Chief Minister of Rajasthan? Shri Bairon Singh Shekhawat. The tenure of Chief Minister is 5. On whose advice does the Governor constitute the Council of Ministers? Chief Minister. How many categories have been placed in the Council of Ministers? 3. Who is the Chief Advisor of the Governor? Chief Minister. In whose hands are the responsibilities of major political and administrative appointments in the state? Chief Minister. Chief Minister who remained on the post the shortest term. Hira Lal Devpura. Who was the first Chief Minister of the scheduled caste? Jagannath Pahadia. Who was the Chief Minister who took oath of Chief Minister for the 3 times in Rajasthan? Sri Shiv Charan Mathur. Who was the first Chief Minister of Rajasthan? Harilal Shastri. Who is the real head of state government? Chief Minister. Legislative Assembly. Constitution of State Assembly. As per Article 170, the State Assembly of each state will be formed in that state from the territorial constituency of the state, elected by the direct election of not more than 500 and not less than 60 other members. But Sikkim 32, Goa 40, Mizoram 40 and Puducherry 30 are the exception. At present, the maximum number of assembly members in Uttar Pradesh is 403 and minimum members in Puducherry 30. There are 30 legislative assemblies in India. 28 of them are in states and 2 are in union territories, Delhi and Puducherry. In the union territory, the assembly was established by the 14th Constitution at Amendment Act 1962 in Puducherry and by the 69th Constitutional Amendment 1991 in Delhi. By the 42nd Constitutional Amendment Act 1976, the constituencies of the assembly were fixed till the year 2000 on the basis of census 1971, and further it was extended up to 2026 by the 84th Constitutional Amendment Act 2001 gave the authority to the government that comparative redeployment of the assembly constituencies should be done on the basis of 1991 census. In the 87th Constitutional Amendment Act 2003, the provisions were made to determine the constituencies in accordance with the 2001 population. In Article 332 of the Constitution, the seats of scheduled castes and scheduled tribes have been fixed for the assembly of each state on the basis of the proportion of population of the state. Originally, these reservations were for the 10 years from the implementation of the Constitution, i.e. till year 1960, but this system was extended for 10 years every time. This reservation has been extended by 2020 by the 95th Constitution Amendment Act 2009. According to Article 170, the State Assembly is formed by the members elected by the adult voters of the state. If there is not enough representation of the Anglo-Indian community in the assembly, the governor can nominate a member. Article 333. In Jammu and Kashmir, the governor can nominate 2 women members in the assembly. In the case of women getting inadequate representation, eligibility of assembly members. According to Article 173, the same qualification has been determined by the Constitution for the membership of the assembly, which is prescribed for members of Lok Sabha. They are as follows. He is citizen of India. He has completed age of 25 years. He meets the condition prescribed under any law made by the parliament. Period tenure. According to Article 172 of the Constitution, Assembly of each state will work for 5 years from the date of its first session. The termination of said period of 5 years will result in the dissolution of the assembly if it is not already disintegrated. The term of state assembly is usually 5 years, but the term of assembly in Jammu and Kashmir is 6 years. Based on the report of governor or the president should believe that the state is not governed according to the constitution, even then the president can declare an emergency in the state and dissolve the assembly. Parliament can increase its term for 1 year in one time during the emergency. If a person becomes a member of both the houses of the state assembly, he will have to resign from a house. If any member is absent for 60 consecutive days without the permission of the house in the meeting of the representative of the respective house of the legislature, his/her membership will be automatically terminated. State Assembly session break and dissolution. According to Article 174 of the Constitution, from time to time, the governor shall call the House of Legislature or every house at the time and place which he thinks fit suitable for the session, and there will be no difference of 6 months between 2 meetings, i.e. the state legislature, both the legislative council and the assembly must meet at least twice in a year, although there may be several legislative assembly meetings in one session. The quorum of the assembly is 1/10 of the total members, but this number should not be less than 10. According to Article 174, Clause 2, the governor may from time to time postpone the house and can dissolve the legislative assembly. According to Article 175, the governor can make an address in both the house of the legislature or in one house or together in both the houses. The governor may send messages or any other message in connection with the bill pending in that legislature in both the houses or in one house. Article 176 provides that the governor shall address the legislature jointly in the first session of the assembly after every election and in the first session of each year. Presiding officer of the legislative assembly. Each house of the state legislature has its own presiding officer. For the legislative assembly is the speaker and the deputy speaker and the chairman and deputy chairman for the legislative council. According to Article 178, members of the Legislative Assembly elect both the Speaker and Deputy Chairman of the Assembly only from its member. Their tenure is till the tenure of the Assembly. The Speaker can give his resignation to the Deputy Speaker and vice versa. The majority of the members of the Assembly can remove them Speaker and Deputy Speaker on the basis of proposal. It is necessary to give notice of the proposal 14 days prior to the Speaker or Deputy Speaker against whom the proposal is. Even after the dissolution of the Assembly, the President remains on his post till the time of the first meeting of the new Assembly. Functions and rights of Speaker. He presides over the meeting of the Assembly and conducts the proceeding of the House. Any member of the House can deliver a speech in the House only with his permission. He accepts the question or rejects them if they are against the rules. In the general situation, he does not participate in the voting in the House, but if any question does not come in favor of the parties and the opposition, then he has the right to exercise a decisive opinion. According to Article 181 of the Constitution, when a resolution is pending to remove the chairman, the chairperson or vice chairperson presiding will not be held even if the speaker or deputy speaker is present. That is, they will not preside over the House. When a resolution to remove the chairperson or deputy chairperson from his post is under consideration, he will have the right to speak in the assembly and to participate in his action and to vote. But in the event of equal voting, there will be no right to vote. The speaker decides whether a bill is a finance bill or not. The speaker presides over the joint session of the Legislative Assembly and Legislative Council. The joint session of the legislature is normal. It is not called on conflict on any bill. The speaker is the only mediator between the House and the governor. Speaker and allowances of Speaker and Deputy Speaker. According to Article 186 of the Constitution, the Speaker and Deputy Speaker of the Legislative Assembly and the Chairperson and Deputy Chairperson of the Legislative Council are given salary and allowances referred in the second schedule of the Indian Constitution or decided by the law or legislature. Pro tem Speaker. When the new Assembly is elected, the Governor appoints the member of the Legislative Assembly as the Speaker of the Assembly, who has the longest experience of member of the House. His main functions are the following: oath giving to the Assembly members, presiding the election process of the new Assembly Speaker. After the election of the new Speaker, his post automatically expires. Powers of Assembly. A. Legislative powers. The state legislature has the power to make laws on the subject of state list. Under Article 356, if the President rule is applied due to dissolution of a constitutional mechanism in the state, the Parliament can make laws on matters related to that state. If an emergency is imposed under Article 352 or 360, then Parliament can make laws on all subject of state list. According to Article 249, if the Rajya Sabha passes such a proposal with a two-third majority in relation to a subject of state list that in the national interest Parliament make a law on this subject, then Parliament can do this. B. Financial powers. According to Article 202, the annual financial statement budget is presented before the legislature in the beginning of each financial year, in which the detail of the government's income and the expenditure are presented. Finance bill is presented only in the Legislative Assembly. The Legislative Council can review and discuss the money bill only for 14 days. If the Legislative Council does not pass the bill in the 14 days, then the bill will be deemed passed. Executive powers. The Council of Ministers is collectively responsible of the Legislative Assembly. Whenever the motion of no confidence is passed against the Council of Ministers, the entire Council of Ministers has to resign. The Legislative Assembly controls the executive through several methods, such as call attention motion, adjournment motion, asking question, censure motion, no confidence motion, etc. The powers of a constitutional amendment. If a constitutional amendment bill which affects the federal nature is passed by both the House of the Parliament, then its confirmation is required by the legislatures of more than half of the states. Electoral powers. The elected members of the State Assembly take part in the presidential election. Oath or affirmation. According to Article 188 of the Constitution, every member of the State Legislative Assembly or the Legislative Council, according to the format given for this purpose in the third schedule of the Constitution, to the Governor himself or any person nominated by him, makes oath or affirmation. By swearing in, each Assembly member vows that he/she will have true devotion and loyalty to the Constitution of India, will keep India's sovereignty and integrity intact, devotedly fulfill the duties provided. Secretariat of State Assembly. According to Article 187 of the Constitution, there is a separate secretariat of the House or each House of the Legislature of the state. Rajasthan Assembly. Key facts. The first election of the Rajasthan Legislative Assembly was completed in 1952. The first meeting was held on March 29, 1952 at Sawai Man Singh Town Hall in Jaipur, which was later made Legislative Assembly House. The new Assembly House of Rajasthan is in function from November 2001, which was inaugurated by the President K.R. Narayanan. During the tenure of Rajasthan's first assembly, maximum number of 17 by-elections were held. In 1953, Yashoda Devi won the by-election from the Praja Samajwadi Party in Banswara. Mr. Haridev Joshi is first politician in India who has been MLA for 10 consecutive terms. The election of 12th Legislative Assembly was completed on the electronic voting machine for the first time. Number of members of Rajasthan Legislative Assembly. First year 1952, number of seats 160. Second 1957, number of seats 176. Fourth 1967, number of seats 184. Sixth 1977, number of seats 200. The first assembly election was held for 160 seats, in which India National Congress got 82 seats and main opposition party Ram Rajya Parishad got 24 seats. For the first time in Rajasthan, the term parliamentary secretary was started by the Chief Minister Mohanlal Sukhadia. First Deputy Speaker of the Legislative Assembly, Lal Singh Shekhawat. First Leader of Opposition, Jaswant Singh, Bikaner. First Speaker, Deputy Speaker and first Leader of Opposition of Rajasthan Vidhan Sabha were Narottam Lal Joshi, Lal Singh Shekhawat, Jaswant Singh, respectively. In the 4th Assembly, March 1, 1967 to March 15, 1972, for the first time, no party could get a clear majority. So from March 13, 1967 to 26 April 1967, President rule was imposed and the Assembly was suspended. The 5th Assembly, March 15, 1972 to April 29, 1977, was the longest term Assembly, while the least working session was of the 6th Assembly, 2 years and 7 months. In the 6th Assembly, the number of members increased to 200 and for the first time under the leadership of Bairon Singh Shekhawat, non-Congress government Janata Party was formed in 1977. This assembly was dissolved by the introduction of President's rule for the third time in the state and for the first time the midterm elections were held. In the 12th Legislative Assembly, for the first time, Sumitra Singh became the Speaker of Vidhan Sabha and Vasundhara Raje Scindia became the first woman Chief Minister. Currently, there are total 200 seats in Rajasthan State Assembly, out of which 34 seats are reserved for scheduled caste and 25 seats for scheduled tribes. Status after delimitation. Leaders of opposition in the Rajasthan Legislative Assembly: Kunwar Jaswant Singh, Tan Loyan, Kunwar Jaswant Singh 1952 to 1956, Tan Loyan 1957 to 1962, Narendra Singh 1957 to 1962, Maharaval Lakshman Singh, then again Maharaval Lakshman Singh, then again Maharaval Lakshman Singh 1962 1977, Paras Ram Maderna 1977 to 1978, Ram Narayan Chaudhary 1978 to 1979, Bairon Singh Shekhawat, Bairon Singh Shekhawat again, Bairon Singh Shekhawat again then. So the total is 1979 to 1989. Professor Kedarnath Sharma, 1989 to 1990. Haridev Joshi, 1990 to 1992. Parasram Maderna, 1993 to 1998. Then again Bairon Singh Shekhawat, 2002 to 2002. Gulab Chand Kataria, 2002 to 2003. B.D. Kala, 2004 to 2006. Ram Narayan Chaudhary, 2006 to 2007. Hem Ram Chaudhary, 2007 to 2008. Vasundhara Raje, 2009 to 2010. Vasundhara Raje, 2011 to 2013. Gulab Chand Kataria, 2013 to 2013. Rameshwar Lal Dudi, 2014 to 2019. Gulab Chand Kataria, continue from 13 June 2019. 15th Legislative Assembly. Election for the 15th Legislative Assembly held on 7th December 2018. The result was declared on 11th December 2018. The Indian National Congress became the largest political party by winning 99 seats and formed government under the leadership of Shri Ashok Gehlot. 25th, Sachin Pilot became the Deputy Chief Minister. Ashok Gehlot became Chief Minister for the third time. Speakers of Rajasthan Legislative Assembly: Narottam Lal Joshi, 1950 to 1957. 1952 to 1957. Ramnivas Mirda, 1957 to 1967. Niranjan Nath Acharya, 1967 to 1972. Ram Kishore Vyas, 1972 to 1977. Maharaval Lakshman Singh, 1977 to 1979. Gopal Singh Bhatrajun, 1979 to 1980. Poonam Chandra Vishnoi, 1980 to 1985. Harilal Devpura, 1985 to 1985. Giraj Prasad Tiwari, 1986 to 1990. Harishankar Babada, 1990 to 1994. Shantilal Chaplot, 1995 to 1998. Samrat Lal Meena, 1998 to 1999. Paras Ram Moderna, 1999 to 2004. Sumitra Singh, first woman speaker, 2004 to 2009. Dipendra Singh Shekhawat, 2004 to 2014. Kailash Megwal, 2004-2019. Dr. C.P. Joshi, 2092 incumbent. Major officials of 15th Legislative Assembly. Speaker Dr. C.P. Joshi. Leader of Opposition Lal Chand Kataria, BJP. Deputy Leader of Opposition Rajendra Rathod, BJP. Deputy Speaker of Rajasthan Assembly Lal Singh Shekhawat, 1950 to 1957. Niranjan Nath Acharya, 1957 to 1962. Narayan Singh Masuda, 1962 to 1967. Poonam Chand Vishnoi, 1967 to 1971. Ram Narayan Chaudhary, 1971 to 1972. Ram Singh Yadav, 1972 to 1977. Ram Chandra, 1977 to 1980. Ahmed Baksh Sindhi, 1981 to 1982. Giriraj Prasad Tiwari, 1985 to 1986. Kishan Motwani, 1986 to 1990. Yadunath Singh, 1990 to 1991. Hira Singh Chauhan, 1991 to 1992. Shantilal Chaplot, 1994 to 1995. Samtaklal Meena, 1995 to 1998. Tara Bandari, 1998 to 1998. Devendra Singh, 1999 to 2003. Ram Narayan Vishnoi, 2004-2008. Rao Rajendra Singh, 2014. From September 18, 2015-2018. Important facts. The first election of the Rajasthan Legislative Assembly was completed in 1952. Mr. Haridev Joshi is first politician in India who has been MLA for 10 consecutive terms. The first assembly election was held for 160 seats, in which India National Congress got 82 seats and main opposition party Ram Rajya Parishad got 24 seats. First Deputy Speaker of Legislative Assembly Lal Singh Shekhawat. First Leader of Opposition Jaswant Singh, Bikaner. First Speaker, Deputy Speaker and First Leader of Opposition of Rajasthan Vidhan Sabha were Narottam Lal Joshi, Lal Singh Shekhawat and Jaswant Singh respectively. Which one of the following is not correctly matched? Chief Secretary of Rajasthan with tenure. So Mithalal Mehta tenure not matched. Consider the following official of Rajasthan State Secretariat. What is the correct descending order of above official? Descending order. So descending order is first Chief Secretary, then Secretary of Government, then Additional Secretary, then Deputy Secretary. How many female legislators are there in the present Legislative Assembly of Rajasthan on January 1, 2017? 27. The first elected democratic government in Rajasthan was formed in 3 March 1952. How many times have President's rule been implemented in Rajasthan state till 30 June 2016? 4 times. How many members of the Rajasthan Legislative Assembly were decided by the Legislative Commission of 1952? 160. In the first general election of the Rajasthan Assembly, which political party was the second highest party after the Congress? Ram Rajya Parishad. How many women of scheduled caste are member of the 15th Rajasthan Legislative Assembly? 8. In the 15th Assembly, which district of Rajasthan elected the most number of women legislators? Ganganagar. Who among the following was the first non-Congress Speaker of Rajasthan Legislative Assembly? Lakshman Singh. In which assembly election the number of members of Rajasthan Assembly increased from 184 to 200? 7th. The Leader of Opposition in the 14th Assembly is Rameshwar Lal Dudi. When was the present rule implemented in Rajasthan due to unclear majority in the assembly election? 1967. Which assembly constituency of Rajasthan is spread over in more than one district in the 2013 assembly election? Nathdwara. Who is the chairman of the executive committee of the 14th Rajasthan Legislative Assembly? Kailash Chandra Megwal. State Council of Ministers is responsible to the State Assembly. What is the number of assemblies in India? 30. Which state has the highest number of assembly members in India? Uttar Pradesh. Which state has the minimum number of assembly members in India? Puducherry. When did the 13th Assembly dissolve? December 10, 2013. When was the 14th Assembly formed? December 13, 2013. Who is the 25th Chief Minister of Rajasthan? Ashok Gehlot. What is the number of female members in the 15th Assembly? 23. Who is the Speaker of Rajasthan Assembly? Dr. C.P. Joshi. Which is the largest legislative constituency of Rajasthan? Jotwada. Which is the smallest legislative constituency in Rajasthan? Basedi. How many seats are there in the Rajasthan Legislative Assembly at present? 200. How long can the Vidhan Parishad hold the money bill? 14 days. When was the first election of Rajasthan Assembly held? In 1952. What is the term of Legislative Assembly? 5 years. For how many seats elections were held for the first legislative assembly? 160. What is the term of assembly in Jammu and Kashmir? 6 years. Which chief minister was the first to start the post of parliamentary secretary in Rajasthan? Mohanlal Sukhadia. What is the maximum number of members of legislative assembly of the state in India? 500. What is the minimum number of members of legislative assembly of the state fixed in India? 60.